Hello friends, welcome to EPG Pathshala. I am Dr. Ajay Solke, presently working as Assistant Professor, University School of Management, Kurukshetra University, Kurukshetra, Haryana. In this module, we are going to deliberate upon Indian labour policy, evolutionary phases of Indian labour policy, what are the key concerns in labour policy environment, recommendations of Second National Commission on Labour. Upon completion of this module, a student should be able to understand the Indian labour policy and how the Indian labour policies are evolved during the various historical phases in Indian context. A student should be able to explain the key concerns of labour policy and how the labour policy environment is characterized. The implications of Second National Commission on Labour in context of labour policy environment. Indian labour policy. An introduction. In every country, the state plays some role in industrial relations. It is, however, the nature of this role, the extent of the involvement and the influence it has over the two other actors in the drama that distinguishes one state or one role from another. The degree of state intervention is determined by various factors such as the political complexion of the ruling party or the group, the economic condition of the country, the history of industrialization and the experience of the main players and the state of development or underdevelopment. The National Commission commented that in some cases state rule has taken the form of laying down bare rules for observance by employers and workers. In others, the rules cover a wider area of relationship and there is equally greater supervision over the enforcement of these rules. Experience on labour policy from other countries. While examining the labour policy environment across the globe, we have some of the evidences from the countries of United States, United Kingdom, Japan, erstwhile USSR, Myanmar, Malaysia, Philippines, Singapore and Taiwan. In the United States, the state has confined itself to enacting legislation for ensuring the workers' right to organize and bargain collectively. It has constituted an independent authority, the National Labour Relations Board, to administer and interpret legal provisions and decide on complaints of unfair labour practices. It is only in cases where disputes or work stoppages are likely to have serious consequences on the economy that government may order a cooling off period. The state also strongly supports a national arbitration system in case the usual expedient of collective bargaining fails. In the United Kingdom, the industrial relations system has been marked by the primacy of free collective bargaining. Even disputes relating to jurisdiction between unions is generally left to the Trade Union Congress. In recent years, it has created an economic system where management are given more and more freedom to deal with their unions. The turnaround began from the Thatcher era when the government disciplined the unions over the coal strike. The Australian system has had a long tradition of state regulation. The government intervenes through the Commonwealth Conciliation and Arbitration Commission for the settlement of industrial disputes and through the Industrial Court to settle differences about interpretation. At the same time, there is a fair scope for collective bargaining. In Japan, the right to collective bargaining is guaranteed under the constitution and the state has enacted legislation to promote it. Direct state intervention is permissible in during strikes which might jeopardize the national economy and public life. There is a central labour relation commissions which may order 50-day cooling off periods. In the erstwhile USSR, three important factors regulated industrial relations during the communist rule. The imperatives of a socialist state, the operation of a centrally planned economy and the overriding presence of the single party in all spheres of existence introduced several constraints on labour and management. The absence of private enterprise did not allow the usual management labour relations to develop, although in later years considerable degrees of autonomy were granted to state enterprises in their relations with the employees. In three developing countries in Asia, Myanmar, Malaysia and Philippines, the role of the state in industrial relation has been more marked. Not only does the state lay down rules and procedures for the settlement of dispute or provide arbitration machinery, but it has to a great extent restricted the freedom of unions to stop work. In Singapore and Malaysia and in Taiwan, the freedom of unions is curbed in significant ways by the state. Thus, there are various types of state interventions in industrial relations. Evolutionary phases of Indian labour policy. Here we are going to deliberate how the Indian labour policy has evolved over the various historical phases. India's labour policy has been shaped by three major considerations: colonial economics, British democratic traditions, and nationalist movement. The three apparently contradictory elements have helped to create a peculiar system within the subcontinent. This system, however, after 1947 has considerably diversified in the countries of the subcontinent like Pakistan, Bangladesh, Sri Lanka or Nepal. In India itself, colonial industrialization helped to create a divide between management and labour, which has been interpreted as a proneness to conflict. The national government, as a result, perceived itself as a dispute settler in the field of industrial relations until the 1990s took this role very seriously. At the same time, the strong democratic principles of British public life have influenced government policy and established a free regime for unionization in the legal framework of the country, quite distinct from the repressive government policies in Southeast Asian countries, which depended primarily on foreign investment. The nationalist movement and the close links of the leadership with the unions have ensured the continuing linkages among unions, political parties and governments in free India to such an extent that foreign investors still find it difficult to understand. The degree of government intervention which is legally permissible in the system is enhanced and strengthened immensely due to these close links. The interim national government in 1946, in recognition of its duty to protect the working class and promote its welfare, drew up a blueprint on labour policy, that is a 5-year program for labour, designed to develop basic labour standards in respect of working conditions, health, welfare and safety in industrial undertakings. The program included statutory prescription of minimum wages, promotion of fair wage agreements, legislation to regulate hours of work, spread over weekly rest periods and holidays with pay for all classes of workers including shops and commercial establishments, road transport services, docks and municipal labour, prescription and enforcement of right standards in regard to lighting, ventilation, safety, health and welfare of workers, improvement of conditions of work, particularly in unorganized industries, organization of industrial training and apprenticeship schemes, provision of adequate housing for workers to the extent of available resources, organization of health insurance schemes for various categories of workers and the extension of social security to as many as workers as possible. By and large, the policy objectives of the new government in 1947 were protective provisions for a weak labour force, apparently unable to stand up to a much better organized management, the imperative to ensure industrial peace and harmony so that rapid industrialization could continue unhampered, the need to develop a framework to sustain an industrial relations system distinct from the colonial hangover, though this was not always possible. In the context of these broad objectives, labour policies and practices began to take shape in India from the mid-1940s onwards, taking an evolutionary path which is not difficult to trace, but this evolution has also been the victim of various events and developments in the socio-economic arena. If it is at all possible to compartmentalize the history of policy making, 7 distinct periods can be identified in this evolutionary process. These are Phase 1, 1947 to 1956, which is characterized as the introductory or initial paternalistic phase. Phase 2, 1957 to 1965, characterized as the tripartite phase. Phase 3, 1966 to 1976, characterized as the fragmentation and conflict phase and interventionism. Phase 4, 1977 to 1980, the post-emergency phase. Phase 5, 1981 to 1990, the phase of creeping reforms. Phase 6, 1991 to 2000, characterized as the post-liberalization phase. 7th, 2001 onwards, characterized as consolidation of liberalization and growth. These phases are discussed at length in quadrant 4 for a deeper insight. Key concerns in labor policy. The key concerns of the policymaker while making the labor policies can be listed as under. Very first is job protection and employment creation, upholding international labor standards and enforcing labor legislation, extending legal protection to the unorganized sector, improvement in living standards, linking wages to productivity, vocational training and skill development, trade union recognition, worker participation in the management of the enterprise at all levels, industrial sickness and attendant problems, social security benefits including pension, occupational health and safety, reforming labor laws based on political consensus among different stakeholders, environmental trends necessitating changes in government orientation towards labor policy. The processes of liberalization, privatization and globalization, it means that the government's role in social and labor matters has to change, not diminish. Paradigm shifts in the government's role and attitude to labor should reflect some of the points which are discussed as follows. Very first of all, the content and the purpose of labor policy and labor law should focus on facilitation rather than regulation, proaction and on the creation of harmonious relations conducive to social and economic development rather than dispute resolution. A decline in the role of the state in economic activity need not necessarily lead to a decline in its regulatory supervisory role in labor and industrial relation matters. In fact, when the private sector becomes the engine of growth, the state may need to play a much stronger role in ensuring a balance between the rights of both labor as well as the management. Secondly, labor policy should focus more broadly on the entire labor force. It should be developmental, not regulatory. There should be a decisive shift towards proactive labor market intervention with the major thrust on the development of skills and attitudes conducive to building a cohesive and productive work culture. Labor policy must be more closely aligned to changes in industrial and other policies. It should provide stimulus to rather than shun job creation. Thirdly, globalization is leading to decentralized industrial relations. There is a serious need to create and strengthen institutions, mechanisms for information sharing, consultation, communication, consensus development at the enterprise and the firm level. Fourthly, the labor market is characterized by dualism. An illiterate, unskilled, unorganized, unprotected and a mute majority of the workforce and a literate, skilled, organized, protected and a vocal minority of the workforce existing side by side. Political unions acting in unison with the state may force it to pursue labor market policies based on political considerations rather than considerations of labor and product market characteristics. The resultant distortions are contrary to the declared goals of equity and efficiency and may even precipitate state and market failures. The state should therefore broad base the scope of labor policy and labor legislation to cover the unorganized sector in a more substantive manner than is currently being done. Fifthly, the state should give up the negative function and assume the positive one of promotion of sound labor management relations. Statistics on strikes and lockout do not always reflect the actual state of industrial relations either at the firm industry state or national level. Here, the state can provide mediation and arbitration services. It can also acknowledge the semi-public status of the labor market, but in democratic tripartite structures. Sixthly, sustaining growth and fostering competitive labor markets is very critical to ensuring job and income security. The demand for jobs does not depend upon the supply of labor. There is a need for a fundamental change in employment and income security measures, employment flexibility, recruitment, transfer, promotion, work assignment, workforce adjustment, they need to be considered dispassionately with due regard to employment and social stability as well as business imperatives, if any. Next is the state should therefore ensure wider social dialogue for broad-based social consensus and social cohesion. Tripartism cannot survive without the state patronage. Despite the long tradition of tripartite consultation in the past quarter century, it was atrophied due to the weak and unrepresentative character of the three social partners. Traditionally, tripartism is restricted to consultations among government and organizations of workers and employers in the organized sector. There is a need to extend the scope to other sections of the society, including the unemployed, the unorganized, and even consumers. Next is there is a growing concern that globalization benefits few but affects many in negative ways. Commitment to rural labor, women labor, child labor, bonded labor, and labor in the unorganized sector so far has been largely rhetorical. And lastly, the state also has an obligation to make social justice an integral part of development planning. Exhortations like sacrifice today for a better tomorrow will not hold much water in societies where the rich continue to get richer and the poorer poorer, as Reach cautioned. Persistent unemployment, underemployment, declining wages, living standards undermine the moral fabric of capital democracy. In a democracy, people will vote for economic dynamism only if they have a fair chance of benefiting from it. Recommendations of the Second National Commission on Labour. Since independence, a plethora of committees and commissions have addressed the issue of comprehensive reforms to various aspects of labour and labour management relations in India. The most important one during the pre-independence India was the Royal Commission on Labour, which submitted its report in 1931. In the post-independent India, there were two national commissions. The first national commission was appointed in 1966. It submitted its report in 1969. Many of the recommendations were not acted upon and they continue to be relevant even today. The Second National Commission on Labour, headed by a Gandhian and a former Union Minister for Labour, Shri Ravindra Verma, was appointed in 1999 and it submitted its report in 2002. Recommendation of Second National Commission on Labour has been organized into certain heads. The heads are named as the approach, trade unions, industrial action, negotiating agent, prior notice under section 9A, chapter 5B, arbitration adjudication, grievance redressal, WPM, contract labour, minimum wages, bonus, Factories Act, working days or hours. The very first of all is the approach. From the commitments of the Government of India, the following right of workers have been recognized as inalienable and must accrue to every worker under any system of labour laws and labour policy. That is, the right to work of one's choice, right against discrimination, prohibitions of child labour, just and humane conditions of work, right to social security, protection on wages including right to guaranteed wages, right to redress of grievances, right to organize and form trade unions, and right to collective bargaining. One cannot overlook the fact that rights are also related to duties. Existing set of labour laws should be broadly grouped into 4 or 5 groups of laws pertaining to industrial relations, wages, social security, safety, welfare and working conditions. Trade unions. It would have been desirable if the Trade Union Act 1926 also provided for a ceiling on the total number of trade unions of which an outsider can be a member of executive bodies. 10% membership requirement should not apply to workers in the unorganized sector. All workers concerned should benefit from agreements whether they are members of that union or not. A worker who is not a member of any trade union will have to pay an amount equal to the subscription rate of the negotiating agent or the highest rate of subscription of a union out of negotiating college. The amounts collected on this account may be credited to a statutory welfare fund. There should be no craft or caste based unions. Provision to set up a separate political fund may be allowed to continue. However, care must be taken to ensure that the general funds of trade unions are not used for political purposes. To strengthen trade unions, the incentives for consolidations can lie in the field of registration and recognition, where the criteria for eligibility can be upgraded or left proportionately upgraded. Industrial action. Strike could be called if 51% or more support the decision through a strike ballot. In essential services, once 14-day notice is given, strike could be deemed to have occurred and dispute must forthwith be referred to compulsory arbitration. The unions which leads an illegal strike must be de-recognized and debarred from applying for registration or recognition for a period of 2 or 3 years. Go slow and work to rule are forms of action which must be regarded as misconduct. Essential Services Maintenance Act should be withdrawn. Negotiating agent. Check-off is favoured with 66% entitling the union to be accepted as the single negotiating agent, and if no union has 66% support, then unions that have the support of more than 25% should be given proportionate representation. The validity of check-off, the tenure of union recognition and wage settlement should all be 4 years. Prior notice under section 9A. The Commission does not see any merit in the statutory obligation for the employer to give prior notice. Notice under section 9A should not operate as a stay under section 33. Through such a decision of the management will be justiciable under section 33A. Chapter 5B. Pay adequate compensation for outsourced jobs to retrenched workers or their cooperatives. If any enterprise decides to close down, give workers or trade unions a chance to take up the management of the enterprise before the decision to close is given effect to. Prior permission is not necessary in respect of layoff and retrenchment in an establishment of any employment size. Establishment employing 300 or more can obtain post facto approval of the appropriate government. Retrenchment is more precisely defined and compensation is less in case of closure of sick units, that is 30 days per completed year of service to 45 days per completed year of service in case of retrenchment in sick units, to make them viable to 60 days per completed year of service in profit making organizations. Arbitration adjudication. Establishment of National Labour Relations Commission NLRC at the Centre and Labour Relations Commissions at the state level under Article 323B of the Constitution are recommended. The National Labour Relations Commission should have same powers as the Supreme Court. Revamp of the Labour Court and introduction of Labour Lok Adalats is favoured. Grievance redressal. Every establishment shall establish a grievance redressal committee consisting of equal number of workers and employers organization. Workers' participation in management. The time has come now to legislatively provide for a scheme of worker participation in management, initially in establishments employing 300 or more persons. For small establishment, a non-statutory scheme may be provided. Contract labour. Organization must have the flexibility to adjust the number of their workforce based on economic efficiency. It is essential to focus on core competencies if an enterprise wants to remain competitive. Contract labour shall not, however, be engaged for core production or service activities. However, for sporadic seasonal demand, the employer may engage temporary labour for core production or service activity. Such labour will, however, be remunerated at the rate of a regular worker engaged in the same organization doing work of a comparable nature. The principal employer will also ensure that the prescribed social security and other benefits they are extended to the contract worker. No worker should be kept continuously as a casual or temporary worker against a permanent job for more than 2 years. Minimum wages. There should be a national minimum wage based on the formula of the 15th Indian Labour Conference. The Commission does not endorse the recommendation of the study group on unorganized sectors regarding the level of minimum wages because it is high but sets even higher limit of need based minimum wage endorsed by the Indian Labour Commission in 1957 as the goal. Bonus. 1 month's bonus would be paid as bonus to every worker. Any demand for bonus up to a maximum of 20% will be subject to negotiation. The existing ceilings for bonus entitlements should be enhanced to rupees 7,500 and rupees 3,500 for entitlement and calculation respectively. Factories Act. There need not be any restriction on the question of night work for women if the number of women workers in a shift in an establishment is not less than 5 and if the management is able to provide satisfactory arrangements for their support, safety and rest after or before shift hours. Working days, hours. We do not approve of the practice of declaring a holiday on the death of a person. On polling days, half day may be permitted to those who have to go to cast their votes. Friends, I hope you have understood the contents well. You can also refer to other quadrants of this module for testing your knowledge and having some more input on theme of the module. Happy learning!